Hello, everyone. My name is Deborah Kidney, and I am in the education department. I'm a field education coordinator for AFSCME, based in the Pacific Northwest. I've been an AFSCME member since 1990 as a member leader and an organizer and a field representative for Council 75 in Oregon, and now I've been with the education department for over 7 years. I've helped lots of members with FMLA questions and taught classes on how to navigate through leave laws. So here's my disclaimer. This class is a broad overview. It's meant for educational purposes and should not be taken as legal advice. It will also not cover your state's medical leave laws, since every states are different. And generally, however, the state's leave laws are better than the federal FMLA laws. The state's laws will prevail. Today's class is going to cover some basic information about FMLA, otherwise known as the Family Medical Leave Act, where it came from, who qualifies, your FMLA rights as an employee, and your employer's responsibilities. You will be able to get a copy of this PowerPoint after the webinar, so you don't have to write all this down madly. After 9 years and 2 presidential vetoes by George H.W. Bush, the Family and Medical Leave Act, FMLA, became federal law signed by President Bill Clinton on February 5, 1993. The law requires covered employers to provide their employees job-protected, unpaid leave for qualified medical and family reasons. So the two most important parts of that sentence I just said are job-protected and unpaid leave. That means that when you have an FMLA qualifying event, you cannot lose your job due to absence, even if you are unpaid during that time. And just sort of as a frame, before we had FMLA protections, an employer could fire you because of absence due to your illness, and they can no longer do that during your FMLA, the times you're qualified as an FMLA for FMLA. However, while your family or medical situation may qualify you for FMLA, there is no provision in the federal law that requires your employer to pay your wages during your absence. The FMLA does give your employer the right to require that paid leave be used. And some of us may have union contract language that designates in what order you use your paid leave, and there are also state laws that cover how and whether employees are in a paid status. What does the law provide? Typically, you are eligible for 12 weeks of protected leave during a 12-month period due to a serious health condition. It also provides for reinstatement or reemployment rights after your leave is done. And it protects you from discipline or reprisals for taking FMLA. Plus, FMLA provides continuation of medical benefits during your 12 weeks, even if you are in an unpaid status, although you would still have to cover your normal amount of medical premiums, co-pays, or any other out-of-pocket expenses. So to qualify for FMLA, there are several requirements. First, your employer has to qualify. That means you have to work for someone who employs at least 50 people who work within 75 miles of where you work. Second, you have to be eligible. So if you've worked for your employer for 12 months and you have worked at least 1,250 hours in that previous 12-month period, you would be eligible for FMLA. And 1,250 hours comes to you working an average of 24 hours a week. And again, remember, some state laws may be different or better than the federal law, so always check to see what your state leave laws say. So let's talk about who. FMLA covers the employee, and it covers when the employee needs to care for a spouse, son, daughter, or parent with a serious health condition. It also covers the birth and care of a newborn child or the placement in foster care or adoption of a child. In addition, many state laws include care for other family members that are not on this list, but I'm telling you what FMLA covers. In 2008, FMLA was expanded for military families in two ways. The first, called qualifying exigency leave, covers an employee or an employee's spouse, son, daughter, or parent who are in the military. It allows FMLA time to deal with the exigencies, kind of a fancy word, of preparing for you or your family member's absence. This FMLA protection is, again, to make sure you have time to prepare when you or one of your family members is called to active duty. This does include National Guard or reserves when they are on active duty or called to active duty status. Second coverage allows an eligible employee who is the spouse, son, daughter, parent, or next of kin of a current member of the armed forces, including guards or reserves, up to a total of 26 work weeks of unpaid leave to care for that service member with a serious injury or illness. This 26 weeks is the exception to the normal 12 weeks of FMLA in a 12-month period. Okay, that was a lot of information, so let's take a little break and try some scenarios to see what you remember so far. So, our first scenario, you've been working for your employer for 2 years, but only about 20 hours a week. Are you covered by FMLA? You get to choose yes or no. Okay, excellent. No is the correct answer. While you've worked for your employer long enough, 2 years, you have not worked enough hours to qualify. The law says you must work 1,250 hours in the previous 12 months, and if you were working 20 hours a week, that actually comes to 1,040 hours in a 12-month period. Okay, next one. Your grandmother has a serious health condition and requires someone to take her to the hospital every Friday for ongoing treatments. Is this covered under FMLA? Yes or no? Let's see how we did here. All right, the answer again is no. While the leave laws in your state may cover grandparents, under FMLA, the federal law, they do not. Only yourself, your spouse, son, daughter, or parent. Okay, let's try one more. Your daughter's reserve unit is being called to active military duty. Can you take FMLA to go with her to take care of financial and legal matters before she is deployed? Yes or no? Excellent. Answer is yes. This is exactly the type of exigencies or challenges that the expansion for military families is designed to cover. Others might be, for example, to attend a military ceremony, to assist with child care on an urgent as-needed basis, or even to take up to 15 days for rest and recuperation to spend with a covered military member who is at home for a short time. So let's move on and talk about, talking about this, you've heard me say serious health condition a number of times. The definition of a serious health condition is very specific when it comes to FMLA. There are 6 basic definitions that outline what qualifies. So first is a mental or physical condition or illness involving care in a medical facility overnight, plus any subsequent incapacity and treatment. So for example, if you go in for surgery, are kept overnight, and miss a few more days of work while you're recovering, that is a serious health condition, even if it was just for surgery on your little toe. Next, disability caused by pregnancy or childbirth or absence for prenatal care is also a serious health condition. That means absences before and after the birth of a child are qualifying events. If both parents happen to work for the same employer, FMLA limits the total time off for both to 12 weeks. However, I know in some states the 12 weeks has been expanded for pregnancy and for after the birth of a child. Serious health conditions also include chronic conditions. For example, asthma or diabetes, where periods of illness may be sporadic. A permanent or long-term incapacity is also considered a serious health condition when treatment may not be effective, for example, because of a stroke or during the terminal stages of a disease. FMLA covers any period of incapacity needed to receive multiple treatments, which might include intermittent leave. In our earlier scenario where your grandmother had to go to the hospital for treatments every week, we said FMLA did not cover her. However, if it was your mother and you were accompanying her for those treatments, that would be covered by FMLA as a serious health condition. If you or your family member are ill and you are absent from work more than 3 consecutive days and the illness requires continuing treatment by a healthcare provider at least twice, that is considered a serious health condition and an FMLA event. Continuing treatment by a healthcare provider means that you or your family member have received treatment once in the first 7 days of the absence and the second time within 30 days of the absence. So for example, you stay home with your sick son who is off school for a week. You take him to the doctor at the beginning of the week and then have a follow-up appointment at the end of the next week. Those 5 days of absence may be counted toward your 12 weeks of FMLA leave in a 12-month period. All right, ready for some more scenarios. You are having a hard time getting your diabetes under control. You have missed a day or two a week for several weeks now because of fatigue and for doctor's appointments. Is this a serious health condition? Yes or no? Excellent. Yes, absolutely. Diabetes is a chronic disease and your absences are covered by FMLA. Next, your daughter is pregnant and suffering from severe morning sickness. She asks you to miss work to take care of her 2-year-old. Is this covered by FMLA? Yes or no? Let's see how you did. Ah, yes, this one is tricky. You're absolutely good reason for this to be a split decision. Actually, the answer is no. If you were caring for your daughter, who by definition has a serious health condition, that in fact would be covered. Providing daycare for your grandchild is not covered. Okay, our last one. Your father was in a car accident and you left work to go to the hospital. They release him the next day. 2 days later, when he's stabilized at home, you return to work and your employer asks you to fill out the FMLA paperwork. Is this an FMLA situation? Yes or no? Excellent. Yes, 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 it is. Your father was in the hospital overnight and subsequently needed care. That is considered a serious health condition. It is qualified as FMLA. So now let's talk about what your requirements are. As an employee, you are required to give your employer reasonable notice when you will miss work because of an FMLA condition. Reasonable notice means that if it is a foreseeable leave, for example, you have surgery scheduled and you will be missing work, you should submit the appropriate paperwork 30 days in advance. Obviously, if you know less than 30 days ahead of time or the situation is unforeseen, like an accident or a sudden illness, as soon as practicable has been interpreted to mean giving at least a verbal notice within 24 hours after the need for the leave is known. When you first need to use FMLA, how should the notice be given? You do not need to expressly state, I need FMLA leave. You just need to give sufficient information to alert your employer. For example, you may say, I'm going to be absent for the next 4 days. And at that point, the employer has the burden of obtaining any additional information necessary, including asking you to provide a doctor's note to certify your absence in order to determine if your leave is for an FMLA qualifying reason. Our employers also have rights and responsibilities under the law. If you give advance notice of an upcoming FMLA situation, the employer can ask for a doctor's note before your leave begins. If you provide less than 30 days notice of the leave, you need to provide the note within 15 days after the employer requests it. Your employer may require a second opinion for serious health conditions. If the second opinion conflicts with the first, the employer and the employee together select the third provider whose opinion will be binding. Requests for second or third opinions are at the employer's expense. Your employer may require you to present certification from your health care provider that you are able to return to work. And your employer may make direct contact with your physician to seek clarification and authentication of medical certifications. But, very important, employers can initiate such contact only through a healthcare provider, a human resources professional, or a management official and a leave administrator. Under no circumstances may your direct supervisor contact your healthcare provider. The law says that there will be no reprisals or retaliation for using federal or state leave laws. Employers are prohibited from interfering with, restraining, or denying exercise of family leave rights. Employees, in fact, may bring civil action, in other words, sue, under FMLA for compensation loss due to employer retaliation, including interest on wages lost, liquidated damages, and attorney fees. As a wrap-up to our overall conversation here, for over 20 years, we have had federal laws in place that protect our jobs and continue our health insurance coverage when we or our family members have a serious health condition. Often state laws have improved upon this right, so be sure you check your state laws as well. Plus, as union members, we can bargain even stronger rights into our contracts. Understanding our rights is key to making sure they are protected for others and for ourselves. So I'm going to give you some more resources. So these are a lot of resources that I've used over the years. We have a small section in our Steward Handbook, our AFSCME Steward Handbook, that covers the very basics of FMLA. We also have a great brochure. You're going to also see it over on your handout. There's going to be a link to, on the handout side, on the right-hand side of your screen, Family Medical Leave Act. And Robert Schwartz's book from Working Rights Press, the FMLA Handbook, is also an excellent source for those of you who are looking for a little more information. And the link that you see is to the Department of Labor Employee Questions, Employee Guide to FMLA. So those are all great places you can get more questions answered and go into more detail.
We just want to thank you so much for joining us today. I want to give a special thanks to our presenter, Ms. Deb Kidney. It's been great. This is good stuff, and the questions show that this is a definite topic that people are hungry to understand a little bit more of.
And thank you, guys.
Okay, so with that, we're going to go ahead on and wrap up. And thanks again for joining us today. Bye, everyone.